So the Supreme Court decided to hear a case that is devastating. In a world that made sense, there's no way they would hear this case. Now, before I continue, let me just say, how fucking dope is this thumbnail for this video? How dope is it? I have to give credit to Lilith, who does all the thumbnails now for the show, and she is phenomenally talented, and she's doing such a great job, and I know that everybody out there watching the videos saw the huge uptick in quality of the thumbnails, and that's all Lilith. So thank you, Lilith, for all the great work you do, and it has really, really added another level to the show that wasn't there before, and, you know, it's just, it's wonderful. So anyway, I think that this is one of the best thumbnails, in my opinion, but I digress. So thank you, Lilith. The Supreme Court, well, let me just throw the tweet up and we'll talk about it. Breaking, Supreme Court agrees to consider limiting EPA's authority to curb greenhouse gases from power plants. We'll hear Republican appeals from coal mining companies and Republican-led states. By the way, Amy Coney Barrett's dad works for, I think, an oil company. And she's not going to recuse herself. I mean, beyond ridiculous, right? Beyond ridiculous. This would be really the death blow in the barely existent fight against climate change. The fact that they're even hearing this case in the first place leads me to believe they're going to come down on the side of the EPA doesn't have the authority to regulate greenhouse gas emissions. And they will use an archaic, primitive, outdated interpretation of the Constitution and what an executive agency can do on their own. So in other words, they are possibly going to make the decision and make the argument that, oh, something like this would need to go through Congress in order for it to be legal. Now, the EPA, the Environmental Protection Agency, is staffed with environmental experts and scientists and people who are incredibly educated on this topic. And so they, you know, can implement rules and regulations and deliver on those rules and regulations in a way that Chuck Grassley cannot. You know, whether it's in the House or in the Senate, you got Republicans who go in there carrying snowballs and throwing them on the ground and saying, see, climate change isn't real. The Supreme Court might say, no, this is an overreach of federal authority. An executive agency can't regulate stuff on their own. Therefore, it absolutely has to go through Congress. And the executive agencies don't have the authority to do regulations solely on their own. And again, if that is the decision they make, we are so beyond fucked. So beyond fucked. I mean, we're already, I don't know if you guys saw this, but at one of these summits of all the world leaders, they got together, they flipped a coin hoping for good luck in the fight against climate change. I couldn't make this up if I tried. And there was a picture posted on social media over it and stuff, and I'm like, oh my God, we're so beyond fucked. And now the new agreement is, you know, by the mid-century, we're going to try to get to, I guess, net zero emissions. Already way too far gone. It's almost like it's a show. It's theater. And they have no intent on even delivering on their meager goals. So while the global community is shrugging and struggling and doing nothing serious and substantive, now they might take away the little power that executive agencies in the U.S. have to regulate big business here. And if this were to happen, and if I had to guess at this point, I'd say they probably will decide the EPA doesn't have the authority to curb greenhouse gas emissions. We're effectively in a new Lochner era of the Supreme Court. I know that sounds wonky, but bear with me and I'll explain it to you. The Lochner era of the court was from about 1900 to 1937, and it was the New Deal that really shifted the balance of power and changed the direction of the Supreme Court. But during the Lochner era, the Supreme Court played an activist role, but it was from a politically conservative position. So they're conservative ideologues, but they, intervened in the legislative process and basically enforced their will. So the court would strike down state and federal legislation that was too hard on business or limited the free market. And so, for example, they would say, hey, a minimum wage law is unconstitutional. Federal child labor laws are unconstitutional. Regulations on the financial industry or on banking, it's unconstitutional. And what happened is the Lochner era ended when Congress intervened with the New Deal and reasserted like a regulatory role. But the story behind the case is it was Lochner versus New York State, and there was a law that limited a bakery from forcing their employers to work too long. So there was a law that said workers are limited to 10 hours per day and 60 hours per week. You can't work them more than that because these workers at this bakery were basically forced to work overtime and they didn't want to do it, but they were compelled to do it. And a 5-judge majority said the law violated the due process clause. And they stated that the law was, quote, an unreasonable, unnecessary, and arbitrary interference with the right and liberty of the individual to contract. So the takeaway from this is they said businesses have a right to contract with their employees. So whatever details you iron out in your contract with a business that you work for, that's ironclad, that's gospel, and the federal government can't intervene and say, we have regulations and this isn't a fair contract. So again, the law said, hey, these people at the bakery are overworked. They're working, 13-hour days or whatever, but we're going to have a law that says you can work 10 hours a day max, 60 hours maximum for a week. And the Supreme Court said, no, if they want them working 80 hours a week, then they could work 80 hours a week. So, in other words, you're basically a slave to the business owner. And if they craft a contract that is exploitative, and you happen to agree to it simply because you need a job and you need to pay the bills, that exploitative contract has force of law. And so if the federal government says, you don't pay them enough, here's a minimum wage law, under the Lochner era, the Supreme Court would be like, no, they agreed to work for basically next to nothing, and they agreed to work all these hours, and the federal government can piss off. You can't have overtime laws and rules. You can't have limits on the amount of time you work per week. You can't have minimum wage. And sorry, it is what it is. Basically, all the employees are subject to the whims of the employer, and the employer could say, hey, you signed the contract. Even if it's exploitative, that contract is solid as a rock, and that contract has force of law. So it was a terrible era, and the Supreme Court were the ones who fostered that on the country. Now, listen, we're getting to a point now with the Supreme Court today where if they decide the EPA can't regulate greenhouse gas emissions, we're getting to like Dred Scott territory where the court can lose legitimacy. And I don't think we're too far away from a place like that. So they're going to need to tread carefully in their own respect, lest they destroy their own credibility and they make themselves politically moot, because they take such insane positions that you can't possibly, in the modern era, defend them, and the practical results of it would be too horrendous. So I don't know how this is going to unfold, but the idea that they might block the EPA from regulating greenhouse gas emissions is ludicrous.